Hi everyone, Miranda Dressler here, attorney with the law offices of Bridget Mackay in Petaluma, California. And we practice in the areas of estate planning, elder law, and trust and probate administration. So today I'm going to talk to you about making changes to your trust. When should you do an amendment to your trust versus restating your trust? So an amendment to a trust is when you have a trust, you want to make a change to it, and that change is made by a separate document that just changes some provisions of your trust or maybe adds a provision. But then now you have two documents. You have your trust and then you have the amendment, and it needs to be read together. A restatement of a trust is basically an amendment to your trust, but in its entirety. So it's basically where you redo the entire trust so that you're just ending up with a completely new trust document. And that's the only document then you would need to read to see what the provisions of the trust are. So there really aren't any hard and fast rules about when a trust might be amended or when it might be a good idea to do a restatement. If the changes are minor, like maybe you're changing who you've named as successor trustee, or you're adding a specific bequest to your trust, then you might want to do an amendment. But there are also reasons why you would want to do a restatement. So for example, if you got your trust done by an attorney, but maybe that attorney retired, or for whatever reason you have a new estate planning attorney and you want to make changes, it's likely that attorney is going to want to do a restatement to your trust, even if the changes are minor, because every attorney's trusts are different. And, the provisions, what it looks like, are different. So in that case, likely a restatement would be done. Another time that doing a restatement of your trust may make sense is if you've made multiple changes over the years to your trust by amendments, and maybe you have 3 or 4 amendments to your trust. It might make sense at that point to basically consolidate all those changes into one document. So it would be easier on you and anyone else who needs to read the trust at some point, like your successor trustee, so that that person is just having to follow one document instead of having 4 or 5 documents that have to be read together, because that can become confusing. And then finally, if your trust was done maybe a long time ago, 10, 20 years ago, maybe the laws change somewhat drastically. In that case, you may want to consider completely restating your trust versus just doing a minor amendment. So if you have any questions about this topic or any other topic, you should contact an experienced estate planning attorney in your area. Thank you.